Hello and welcome to BloombergQuint. You're watching the fine print. In the latest in the Karvy crisis, the Securities Appellate Tribunal, or SAT, has told lenders to make their case before market regulator SEBI. Now remember, on November 22nd, via an interim order, SEBI had barred Karvy stockbroking from taking on any new clients. The depositories were also directed to not execute any instructions from Carvey. The brokerage firm has been accused of pledging client securities to raise money from 5 lenders, including Bajaj Finance, HDFC, ICICI and IndusInd banks. The lenders are seeking transfer of shares that Carvey had pledged with them. These shares were transferred from the lender's account to over 83,000 beneficiary accounts on SEBI's directions. As these lenders make their case before the market regulator, there are some preliminary questions that this case raises. What is the market practice around broker-client power of attorney? Do lenders do any due diligence to ensure that the shares being pledged belong to the brokerage and not the clients? And finally, what relief can lenders now hope for? To answer these questions, I have with me Pratibha Jain from Nishith Desai Associates and Sanjay Asher of Crawford Bayley. Sanjay, Pratibha, welcome to the fine print. Pratibha, there's a 2010 SEBI circular that specifically lays down what a broker can or cannot do with a client power of attorney. Is this circular, strictly adhered to by brokerages, and what is the market practice around it?
So Payaswini, the financial services industry is very highly regulated, and especially the brokerage business is highly regulated by SEBI, and clear rules have been laid down in terms of what the securities that are provided or bought on behalf of clients by brokers, what they can be used for. So the power of attorney also clearly lays down the broad parameters under which they can be used by the brokers on behalf of clients. There are enough and many regulations that clearly state that brokers cannot use clients' money or client securities for its own beneficial purposes, and it can only be either pledged or used for fulfilling clients' margin requirements or other payout requirements. And clearly that is something that, given the importance, you're acting as a trusted advisor to your client. As far as we know, this is very strictly adhered to in the market. So the Carvey case really, came as a surprise to all of us.
Okay, Sanjay, with what Pratibha is saying, then is it safe to assume that Carvey did abuse the power of attorney that the clients had given to the brokerage? And is there any room after the guidelines that SEBI has laid down in the 2010 circular and even in June 20th this year with regards to what brokerages can do with this power of attorney?
Absolutely, I would agree with Pratibha, that is one. Number two, irrespective of the SEBI circulars, the law on the power of attorney between the stockbroker and the client is very clear, and there are enough number of judgments not only today, but even if you go back 50 years, when the market was still developing, had not developed at all, yet there are judgments which clearly point out that, look, a stockbroker cannot abuse, cannot use, pursuant to the power of attorney, any of the client securities, any of the payments which is due to the client or any such thing. The stockbroker has to absolutely work within a very, very strict and a limited framework. And therefore, clearly, Carvey has abused it wholesale, the power of attorney, which it was under an obligation not to abuse or not to even use it.
Okay, all right. So, Pratibha, the first leg of, this Karvy crisis was this power of attorney, which both of you seem to suggest, and even the interim order that SEBI put out, that Carvey did abuse this power of attorney. Now this, leg of the transaction is completely regulated, but what's a more contractual arrangement is what goes on between the lenders and the brokerage. And what seems to have happened here is Carvey, transferred the client's share into its own account, and that's what lenders used as collateral to then lend money to the brokerage. Can you weigh in on what is the market practice or on the due diligence that lenders usually do before they lend money, in using pledged shares as collateral?
So again, Payaswini, this is not like some bespoke M&A transaction. These are standard transactions that happen on a regular course of business between brokers and lenders, specifically for undertaking their broking business. Now, what it's unclear and what I can make out from the interim order is that possibly what happened was that the securities were pledged from the pool account, so the lenders wouldn't even know, because you could, before the 2019 circular, pledge the securities from the pool account, but it was supposed to be used for the purposes of meeting any requirements that the clients had for their transactions. But then that money that came from pledge of these securities were transferred by Carvey to their own account, which were not disclosed to SEBI. So in that scenario, there is no way for the lender to know that the money is being siphoned off for use by Carvey for its own purposes rather than for client purposes. If that is the situation, then, as per the current law and procedures in the market, there is no wrongdoing on behalf of the lenders. What will have to be seen is, if all accounts for transactions where the pledge of securities happened were done in this manner, or there were any pledges that happened from Carvey's own account.
Okay, Sanjay, weigh in on this as well. Is there some sort of comfort that lenders look at, whether it is, looking at the board resolution of the brokerage or the audit committee approval, or let's say a master statement from the depository before they enter into such transactions?
Yeah, I would personally feel that, look, the lenders have clearly not carried out proper due diligence. Because if you go to a DP and you get a transaction statement, you clearly will know where the shares have come from and from which account it has come from. Now, take an immovable property. If you're taking an immovable property, you do a title search. Why don't you, when you do a pledging of the shares, why don't you do a clear title search on the shares as well? Whether it is an M&A transaction, lending transaction, at the end of the day, one needs to check as to whether the person who is pledging the shares owns the shares legitimately or not, or whether they are shares which have been stolen, the shares which have been owned in a manner which is illegitimate. And so, in my view, clearly the lenders should have done proper or a detailed due diligence before even, not before, but at the time of lending the money or taking the pledge.
But would the, let's say, depository statement...
Not carried out their due diligence exercise.
Payaswini, can I just...
Yeah, please, Pratibha, go ahead.
Sorry, Payaswini, let me just add. So what Sanjay is saying, right, in case the accounts that Carvey used were their own accounts. But if they were using what is called the pool account, which is where securities are pooled in by the brokers legitimately under SEBI regulations, and then used for pledging for meeting clients' margin requirements or other requirements. In that scenario, lenders would, even if they look at where these securities are coming from, they would see them as securities held by Carvey on behalf of the client, and hence assume that they are following their the regulations applicable to them by SEBI regulations, which would require them to ensure that these monies are then used only for client purposes. Now, the 2019 circular of SEBI has now mandated the depositories and the clearing corporations to tighten their supervision of money being used from these accounts for the purposes that have been mandated by SEBI. But if this was used from the pool account, then there was no way for lenders of knowing or even needing to check whether the money was being, how the money was then being used by Carvey.
Okay, so Pratibha, tell me this. Let's say you are a bank and I am the brokerage, right? And I show you these shares lying in my pool account. Would you as a lender not want to look at any, let's say, board approval or audit committee approval that specifies that this money that I'm using from you, the bank, is going to be used either for meeting client margin requirements or for meeting other requirements? Is that not a comfort that a lender would seek?
Sure. No, so the lender would seek that. That would be a covenant in their loan agreements, but that would be post facto, right? So they provide the loans to the banks, and then the banks are supposed to use it for client purposes, right? Then if they go ahead and misuse that money, that is all post facto of bank having given the loans.
Sanjay, even the financials of the brokerage will not show if the recent audited financial statements are in the public domain or lenders have access to it, that what are the securities that the brokerage owns, or the ones that it has transferred to itself in the pool account of that shares that belong to the clients.
No, absolutely. The lenders should have taken first, would have seen whether the brokerage has passed a resolution under 179 of the Companies Act, and which is a pre-resolution which is required, and the minutes of the board meeting authorizing the committee or the officers to borrow money from the pool account. That is number one. Two, would have taken a certificate from a chartered accountant or from the statutory auditor to the effect that the money, where is it going to be used, how are they raising this money, for what purposes, where the shares are coming from, whether it is being used for the margin money of their clients or for any other purposes. So surely the lenders should have asked for the audit committee and the board resolutions, as also certificates from the statutory auditor of the broker of Carvey.
Pratibha, in the context of what Sanjay is saying, do you still sort of believe that for the lenders, there was no way of knowing that these shares didn't belong to Carvey?
So, like I said, Payaswini, the shares are in the pool account. They don't belong to Carvey. Would be something that the lenders would already know. They are then not tracking where the money is then being used, in breach of regulations and in breach of contract. That would all happen.
Sorry, you're saying the lenders
now, this
would.
is all assuming that the transactions that we are.
Sorry, you're saying the lenders would know that since the shares are lying in the pool account that they don't belong to Carvey?
Yes, because the pool account is basically a client account where all the securities are pooled for the purposes of pledging these securities. So it's legitimate to pledge securities from the pool account for the purposes of taking money to meet, let's say, clients' margin requirements, right? So all of this is per se the brokers are authorized to do on behalf of client. Where the misuse is, instead of using it for client purposes, they use that money, they transferred it not to the client account or for client purposes, they transferred the money to their own account.
Sure, I get your point. Now, so in such a case, the brokerage would give the undertaking to the lender that this money that I am raising against these pledges is to meet the client margin requirements and not then for any other purpose.
Exactly.
Okay.
And so it would be a breach of covenant, but then lenders can only act on it post facto.
Okay. Sanjay, you wanted to add something?
I just wanted to add that even if the securities are in the pool account and the money is being borrowed by pledging the pool account shares on behalf of the client for margin money requirements, there has to be a clear mandate from the client to the brokerage for the purpose of pledging the shares to raise the margin money. Now that is the due diligence which I am saying that ought to have been done by the lenders even while funding the margin money and pledging the securities from the pool account.
So, but then Sanjay, that goes to my previous question,
there
that
are
if you
judgments
have
directly.
No, I'm saying if you have this all-encompassing power of attorney that allows the broker to do these pledges and raise that money, is that approval specific to each transaction that then the brokerage does, or clients give a general power of attorney which is still restricted to say that, look, you can pledge these shares if I'm short in margin and I'm giving you this consent for all transactions henceforth, and then it's not then a specific approval that the broker has to go and seek from the client, which then the lender can rely on to be sure that this is in fact a legitimate transaction.
No, Payaswini, there are direct judgments way back of 1947, whereby it's very, very clear that even if that power of attorney is there, that does not authorize the stockbroker to exercise that particular power in the way that the shares would be pledged, money would be raised, and use it for the purposes for which Carvey has used it for.
Okay,
and so therefore the point which I am trying to make here is that there should have been diligence, because there are direct judgments way back right from 1947.
Okay,
directly on the subject.
Okay, so
directly on the stockbroker and the power of attorney, and under what circumstances the power of attorney can be used, cannot be used.
Okay, that's fair, and I think both of you have sort of.
So the lender should have exercised that particular diligence.
No, so clearly both of you have agreed that there has been an abuse on the part of Carvey, but what I'm trying to come to is that whether there was any negligence on the part of lenders here, Pratibha, when clients give this power of attorney to brokers, and let's say there is a shortfall in the margin that they're supposed to give to the broker, for every pledge that the brokerage does, do they need to seek a specific consent on that transaction, or does that power of attorney is all inclusive for all transactions whenever a margin requirement comes up?
So, Payaswini, you're right. It's a general power of attorney. So, every transaction is not required to be approved.
Please go on, Pratibha, go on.
Sorry. So it's a general power of attorney, which, even if you have a brokerage account today, you don't need to go back and take client's consent each time. Basically, otherwise there wouldn't be a smooth running of the capital markets. When you allow what you allow the broker to do is operate your account as and how they deem fit under the SEBI regulations. SEBI regulations, what Sanjay is saying is clear, that whether you go by judgments or even the SEBI circulars in this regard are very clear. There are multiple circulars which specifically state you cannot use clients' money or securities for your own purposes. You've got to keep a clear demarcation between your money, your securities, and client money and client securities. However, the lender will not be able to know that this money is then being siphoned from client account to the personal account.
So besides an undertaking, lenders have no sort of comfort from the brokerage when it comes to use of these funds that have been raised on the back of pledged shares?
Yeah, that would be post facto. They would, they could create an escrow on these accounts, but that's not standard in the market at all, not at least for securities markets, right? This is something that you're doing in the normal course of business.
Okay, all right. So given what the both of you have said, and given that SAT has directed these lenders to make their case before SEBI, Sanjay, what relief can these banks now hope for, given that via its interim order, SEBI has already directed, and those transactions have already happened, that those shares, the pledged shares, have gone from the account of probably these lenders back to those of beneficiaries. So what is the relief that these banks can now hope for?
The banks can only hope for the relief from the regulator to get back the money. Nothing else except that. And two, to my mind, it will not end here. Before SEBI, they will necessarily have to take it to the court for the purpose of recovery of this money. So
Okay.
even that, in other words, the lenders may not get practical reliefs from SEBI.
Okay. Pratibha, would you agree that this is something that, since SAT has sent it back to SEBI, and, the Allied Financial case comes to mind where, SEBI is arguing before the Supreme Court that this is a dispute, contractual dispute between the parties, and SEBI has nothing to do with it, and you can't ask us to investigate, transactions between parties. Is this sounding similar, that now the contract between Carvey and banks is between them, and the regulator, which is mandated to protect the interests of the larger public market, has done so via the interim order?
That's correct, Payaswini. Even though there is a recent notification under IBC, where you can now take financial companies that are systemically important for insolvency, but that has to be done at the direction of the regulator. Here, SEBI's primary goal would be protection of the retail investors that have given the brokerage mandate to Carvey. So I think I would agree with Sanjay that SEBI will first see how the interest of the investors is protected, and given that as a securities market regulator, that's their primary job, and then the lenders will have to figure out if there is enough liquidity and solvency for them to ask and SEBI to give them the approval to take them for insolvency to recover their money. Otherwise, you'll have to follow the normal course of business in terms of recovering the money.
And that normal course of business obviously will not lie before SEBI, right?
Absolutely.
That's right.
Okay, all right.
Absolutely.
Sanjay?
SEBI cannot settle the dispute between the lender.
Yeah, please go on, Sanjay.
No, I was only trying to say SEBI will surely not be able to settle the dispute between the lender and Carvey. They can only protect, as Pratibha said, protect the investor's interest, and the lenders will necessarily have to file a separate suit or take it to IBC.
All right. So, if I can sum up your
And
views.
lastly,
Yes.
I still feel,
Sanjay.
lastly, Payaswini, I still feel that the lenders could have carried out the diligence, because the broker, for example, if I am placing an order, they have a diligence mechanism for the purpose of placing the order for buy or sell. Similarly, if at all there is a pledging of the shares even from the pool account, there has to be a mechanism which the broker has not followed, or which has not followed and in turn checked by the lenders while carrying out the diligence.
So what would the diligence show? Like Pratibha said, right, that once the shares are in the pool account and brokers constantly pledge those securities to meet margin shortfalls of clients, how can the lenders be sure that the money that's being raised is not for that purpose and for siphoning it off elsewhere within any of your group companies of the broker?
No, I'm only trying to say that whilst the shares are lying in the pool account, they belong to the clients of the brokers. Now, by a mere power of attorney, it's not is not sufficient for the purposes of the broker to pledge those shares from the pool account.
But that's what
A blanket power
Pratibha, that's
of
what
attorney,
Pratibha said,
to my
right?
mind, is a dustbin paper.
But that's what the market practice is, and I'm not sure if any of the SEBI circulars require
Sanjay,
you to.
Yeah, today even if you open a brokerage
Payaswini,
account,
there are two
you
things.
will sign
One is
a
the SEBI
GPA
regulations.
that will allow. So because
Sanjay, I'll just come to you. Pratibha, can you finish your point? Then I'll go back to Sanjay.
Sure. No, I'm just saying it's definitely the general power of attorney is something that is recognized both by the exchanges and SEBI, because that's the only way a brokerage house can also function, right? Because if I am allowing the brokerage house to buy and sell securities on my behalf, yes, I open a margin settlement account, but if there are shortfalls, I have to ensure that there is settlement on T+1. So all that money moving has to be done by the broker on behalf of the client. Otherwise, you can't have an efficient securities market.
Sanjay, you want to quickly make the last point before I went to Pratibha?
I'm only making a point. I want to make a point. One is the securities laws and the securities market, and the other one is the law on power of attorney. They're two different things. Merely because the regulator has made this power of attorney is not sufficient from a legal perspective. And there has to be something more, especially when you are lending large sums of money from pledging the shares from the pool account.
Okay, perhaps after this incident, those strictures might come into the securities law as well. Pratibha, Sanjay, many thanks for giving us your quick thoughts on how the Karvy crisis is likely to play out and whether lenders can be held to be negligent in this case and the relief that possibly lies before them. Thank you for joining us here on The Fine Print. We'll see you next week.
ये क्या? एक हफ्ते की ट्रिप के लिए पूरी अलमारी पैक